Great. Good morning. I suppose everybody got up this morning. They put on their I Love Jackie Weaver t-shirt. They checked the Zoom filter, cat on or off. And then they thought, what else are we going to do? I know. Let's attend not just another webinar, and let's think about what is coming on the 6th of April, the reforms to the giving of witness evidence. It's been talked about for a long time. It's now here. Before I just sketch what we're going to cover, let me introduce those who are going to do the heavy lifting, the frighteningly clever team who are going to explain what it all means. I'll start with Johan Ho, who this irritates him beyond belief, crossed from the dark side, used to be a solicitor, I know, and is now counsel. Ruth Keating, dual qualified, both in Ireland and in England and Wales. She was a judicial assistant in the Supreme Court, as was Philippe Kuhn. Together, we're going to pick it apart. We've had some questions in already. Thank you so much. We're going to try and address those. There are some themes coming out of the questions that have been submitted. You've got a chat function and you've got a Q&A function. Could you put the questions to us into the Q&A function, but we will try and monitor both during this process. Okay, lots to cover. Let's start. Practice Direction 57 AC. I don't know why. Why do they give us these numbers? These things we have to remember. How are we going to structure this? Well, we've got 10 points that we want to cover. First of all, we want to identify the problems that led to these reforms. You've got to understand those if you're going to understand the implications for other forms of dispute resolution. We then want to look at the overall scope because it doesn't apply to all proceedings, and we want to identify those that it does apply to. That's the first two topics. Topics 3 and 4 are all about certification. We're going to look at the lawyer's certificate of compliance, and then in topic 4, the confirmation of compliance that a witness now has to give in addition to a statement of truth. The next two, topics 5 and 6, will be drilling down into the statement of best practice, which we are all now going to read and understand, and the listing of documents, a controversial proposition, which from what we can see is generating a lot of concern. We then want to look at, if not witness statements, topic 7, how else can we deploy evidence that we were getting in under the old form witness statement? Topic 8 is headed naming and shaming. I think you can guess what we're going to be talking about there. And topic 9 is the costs implications, because your budgets will have to be reviewed, we think, and you're going to have to take a different approach to the assessment of value in the new budgets, given this practice direction. The last one, point 10, is to step back and to look at the implications for the users of adjudication and international arbitration, because as many of you will be aware, the ICC in parallel has been looking at this issue. It was in parallel, it didn't overlap, but we're hoping that moving forward, it will overlap. So that's what we're doing. Let's get on with it. And let's start with topic number 1, which is the problems that led to the proposed reforms. Now, I thought when I looked at this that there were 3 strands that were worth bringing out in this. The effect on memory and the work that's been done on that. Secondly, the use of a witness statement as a vehicle for inadmissible, frankly, evidence, submission, not evidence. And thirdly, good old-fashioned dishonesty. So let's start with that. Ruth, can we talk about the memory? And that's not the song, not the cat's song.
Thank you for that prompt. So Marion, looking at the cases, there's a couple of themes that come out. And the headline point, very much as you say, behind the ICC work that is being done and also this new practice direction, is the headline point that human memory is unreliable. And part of the reason for that, of course, is that we think of human memory as this fixed mental record in our minds that simply slowly fades over time, for some fading faster than others. But in fact, the difficulty we have, and this particularly comes to the fore in litigation, is that human memory is a malleable thing. And every time we retrieve a memory, this is what the studies are telling us, it changes slightly. And so what that means is that it's particularly vulnerable to influence or alteration when a person is presented with new information or certainly suggestions. And I think, Marion, we can very clearly see then that the scene is set for difficulties that arise in the litigation context.
Now, Philip, you could explain that, can't you, how that feeds into the litigation process?
Absolutely, Marion. The process of civil litigation is well known to subject the memories of witnesses to very powerful biases. And a common problem is that they often have a stake in a particular version of events that may be due to loyalty to an employer or having been a core participant in what happened and is the subject of the dispute. For our purposes, perhaps more significantly, the process of preparing a statement often interferes with memory. And common reasons for that are that the statement is taken years after the relevant events, especially if you're close to the limitation period. The lawyer taking the front seat in drafting the statement for the witness and being aware of the significance of issues in the case in a way that a witness naturally recounting the events wouldn't have been, or not necessarily to the same level. And there's also the common problem of a witness's memory being refreshed by reading documents. And this is something that we'll look at in some detail in this webinar. And another common criticism and problem is that the statement may go through several iterations and versions, and that departs a lot from the initial version of events that a witness might have started with. And that also establishes in the witness's mind matters that may not have really been at the forefront of their memory.
Yeah. I mean, one of the themes that came out to me from the work we've been doing preparing for this is the increased reliance there is going to be on the documentary record. That's one of the key takeaways, I think, from all of this. There is a skepticism about what the use of a witness statement is, which I think takes us into your points, Johan, because people, am I right? There's a feeling that they have been using witness statements as a vehicle for material that ought not to be there.
That's absolutely right, Marion. And there have been a string of cases criticizing witness statements, some in very trenchant terms and with cost consequences, for witness statements that are used inappropriately. So some of the common criticisms are that witness statements simply recite facts based on the documents the witness has read. Sometimes witness statements give opinion evidence. And sometimes witness statements advance arguments and make submissions. That's a persistent difficulty because of the nature of witness statements and the language of recollection we use. But if one takes a step back and recalls the original purpose of witness statements, that they're meant to stand as the evidence in chief. And can you imagine a witness giving oral evidence in chief making all of those points? I think that answers the question.
I can remember taking a witness in chief. It was a nerve-wracking experience. Let's talk about the next topic. I'm just going to call it lying. Does this go on?
Yes, Marion. So that's the kind of snappy title to get everyone's attention. And that's certainly true. Lying is not a new phenomenon, and it's certainly not a new phenomenon in cases. And it very much relates to this question of witness evidence we're talking about. I think what's useful to look at is a judgment of the High Court from last year, a National Bank Trust in Euro. By way of background, lying and fraud very much at the basis of that decision. It concerned majority shareholders and supervisory board members of a Russian bank who loaned very significant amounts of money to their own companies, unsurprisingly. And what they had done was knowingly falsified bank accounts and concealed bad debts, unsurprisingly leading to the bank's collapse. But for our purposes, Marion, what's important is that when the word lie is mentioned in a judgment 33 times, I think we have a fair idea that perhaps some of the witnesses were not to be believed. And that is certainly reflected in the judge's decision. And what the judge said was, Mr. Yurov's willingness to invent a story and lie on oath, demonstrating that he is not a witness of truth and that his evidence cannot be relied upon. So certainly not an unusual occurrence to lie in the course of witness evidence. And we can see they're happening very recently and at scale in the High Court.
So what we have are those three themes, if you like, part of the baggage that a common law trained English practitioner is going to bring when they're sitting as a neutral determiner. And I think we'll pick that theme up later on. Now let's move to point 2 and the scope of the practice direction, because I said confidently it doesn't apply across the board. Let's just drill down into that. I mean, Philip, what's the scope? Where's it?
I mean, to give a bit more of the background, so this practice direction is the product of about 2 years of work by the Witness Evidence Working Group, and they started considering possible reforms in 2018. We now have a kind of conclusive statement on what's in and what's out in PD 57AC, and that's now available on the judiciary website as of 2 weeks ago. And it'll apply to witness statements for use at trials in the business and property courts. So that's mainly the commercial court, Chancery Division, and the TCC. And Johan will go into that in more detail. And importantly, it applies to new and existing proceedings. So it's not just things that haven't been issued yet, but only to trial witness statements signed on or after the 6th of April, 2021. And Johan will take us through the more specific exceptions in the PD.
Can we just, before we do that, can I just say, we've had a question in about what do you do in existing proceedings when you're drafting statements now, but they will be for service after the 6th of April. And you've got to watch that signed on or after. Speaking personally, I would be a little suspicious about 10 witness statements that thumped on the desk from the other side, all signed on the 5th of April, but served, say, on the 1st of May. You'd think, gosh, how organized. What drove that? What was the rush to get this out on the 5th as opposed to the 6th or the 7th? So just think about that. It is signed on or after. Johan, sorry, I butted in. The exceptions. What are the exceptions?
Well, happily, for those who fall into the exceptions, you don't have to line up with the other guinea pigs for this practice direction. So there are some notable exceptions. There are certain Insolvency Act and Companies Act actions that are not subject to the practice direction, but notably certain of these proceedings are still subject to practice directions, such as Section 994 unfair prejudice petitions. Notably, proceedings in the TCC relating to adjudication awards under Section 9 of the TCC Guide are not subject to the practice direction, and there is a smattering of other exceptions, such as specialist FISMA, IP, probate wills claims as well. But having said all of that, there is a power in the practice direction that the court may at any stage direct that it will apply to these proceedings.
Yeah, and that's a theme, isn't it? There's the power to apply and disapply throughout. Philippe, is there a rationale behind that list of exceptions?
Yes, quite helpfully, there's an implementation report from the working group. And if anyone wants to read in more detail, paragraph 10 deals with this. And the nub of it really is that the committee or the group thought that there was a problem endemic in the litigation of well-funded, document-heavy business disputes in those 3 parts of the High Court. And interestingly, the judges in the Commercial Court and TCC who were consulted on these reforms said that they didn't see the same issues which this PD is trying to address as much in other parts of the QBD.
Let's watch this space for the general rollout. Let's move, I think, now to, I thought I saw those words I hate, for the avoidance of doubt in this practice direction. What was that?
So we all hate seeing that, I think, for the avoidance of doubt. I think it raises a huge amount of doubt as soon as we see those words. But what it says in the practice direction is it says that it doesn't affect affidavit evidence. The practice direction won't apply to evidence in a witness statement other than a trial witness statement. But of course, we have that beautiful catch-all at the end where it says, and it also doesn't impact the general powers of the court under Rule 32.1. So that's the general power to control, exclude, or limit factual witness evidence.
Yeah, and I suppose the rationale behind making that clear was that they will accept that in a witness statement used for an interim application, there will be an element of argument in there, and it's quite convenient to have it there. That's the solicitor's explanation as to why the relief is sought. That makes sense. Well, let's move on while we're picked up now on the use of the word solicitors. Point 3, the certificate of compliance from the lawyer. I think we ought to screen share at this point, and which is not an invitation to show the confidential work and to breach the GDPR regulations. Now, take me through this, Johan. What is this all about?
I've put up here paragraph 4.3 of the practice direction. And you can see here it says that a trial witness statement must be endorsed with a certificate of compliance in the following form. So you have to have these prescribed words in there. It has to be signed by the relevant legal representative, which I'll come to in a moment. And when we see what has to be certified, there are 3 points. First, you certify you are the relevant legal representative, you're the correct person to certify. Number 2, that you personally are satisfied that the purpose and proper content of the trial witness statements and proper practice in relation to their preparation, including witness confirmation, has been discussed with and explained to the witness. So you have to make sure you've actually done that. And you then have number 3, and this is where it gets quite onerous, you have to believe that this trial witness statement complies with the practice direction and paragraphs 18.1, 18.2 of PD 32. And it has been prepared in accordance with the statement of best practice. So that's the appendix. So that is really quite something. You have to confirm your belief that it's compliant with the PD and the appendix. Now, I've mentioned relevant legal representative here. This is a defined term within the practice direction. And it means a legal representative authorized to conduct litigation who has had responsibility for ensuring that the purpose and proper content of trial witness statements and proper practice in relation to the preparation has been explained to and understood by the witness. So I think this probably means the partner with conduct of the matter, and the buck stops there. Now, a litigant in person does not have to sign a certificate of compliance. So this form is designed for legal representatives. But in order to avoid any abuse of that, what the PD says is that if the court has reason to consider, so that's how low the threshold is, reason to consider, on its own motion or upon application, that a litigant in person became a litigant in person to avoid the need for the certificate of compliance, the court may strike out the trial witness statement. So that's how draconian it can be as well. What the working group said when they considered these provisions was that this would encourage witnesses and solicitors to focus on the relevant requirements without adding substantially to cost. They said it would give solicitors grounds to push back if the client insisted on including inappropriate material in a witness statement. And it said, it gave a warning that the named solicitor, the person who signs off on this, would be at risk of being identified if criticism is subsequently expressed. So it's a really powerful tool. The role of the solicitor in trial witness statements is now that of a gatekeeper. You cannot disown witness statements as not belonging to you, but rather to the witness alone. The buck stops there. You have to certify and confirm your beliefs, compliance with it. And if the client gives instructions that you have to submit it, you can say, no, I'm not willing, I cannot certify this accordingly.
We had a lot of questions about this, and I mean, pragmatically saying that the task of taking witness statements is delegated. It's to make it cost effective, cost bearable for the client. It is quite often done by junior members of the team. It's quite often done by in-house counsel. It's junior counsel are brought in. What is this certification process going to mean for that delegation process? Any thoughts on that?
I mean, I think personally, the key point is that the partner still has to take ultimate responsibility as the person having conduct. I mean, the use of junior counsel and delegation to experienced associates in that process, I don't think will stop. And if you suddenly showed up at a CCMC with a cost budget which envisaged the partner suddenly doing all of that work, I think that would be equally puzzling. But I think it requires a slightly more careful approach to the supervision and ultimate arrangement of that process, and a lot of planning as to how it's going to work and the stages.
Yeah, you would want to know you have reasonable grounds for the belief that you're going to certify you hold. And given that it's the naming and shaming that you referenced, Johan, you will want to know that where your firm's reputation is involved, that you have robust processes in place, which will give you the required level of comfort before you sign. Let's look at the certificate of compliance for the witnesses now, point 4. And if anyone's got any questions, do please, the Q&A box is there and we are monitoring it. And we've been dealing with. Do please, Ruth, now screen share. Let's have a look at the compliance for the, was it Johan? Are you doing the?
I can put it up. Just before I put it up, just to complete my thought of what you just said, Marion, I think it's not only the reputation of the firm, but it's the reputation of the person who signs it. The partner who signs off has to put his name and his position, and the court has made clear that the naming and shaming would be of that person. So it's not simply this firm has not done it, it's this partner with conduct of the matter has certified it, and I do not understand how he or she was able to do that.
I mean, that's what they did with expert witnesses in the TCP name, absolutely no. And Halliburton, where the Supreme Court couldn't understand why anonymity had been given to the panel, let alone the particular arbitrator. Yeah, and the questions are coming in. What about possible disciplinary action flowing from it? And you will remember that happened in the expert field with Professor Meadows facing a major regulatory attack. What about CFA cases? If you as a partner cannot certify the witness statement, I think our message to you is very clear. If you can't certify it, you're going to have a problem. Let's talk now, why do we think it has to be a partner? I can take the point. It may not have to be that precise rank, and you could dance around employed or salaried or an equity share, but it has to be a senior representative, it seems to us. And what you would be looking at is, I mean, who signs the disclosure? Who signs statements of truth on behalf of the lawyers? When dealing with statements of case, you'd want to align your practices there. Sorry, Johan,
yes.
Share the screen again. Let's have what the witness now has to sign.
So what I've put up here is paragraph 4.1 of the new practice direction, and it requires a confirmation of compliance by the witness. And there's a prescribed text here. And what the witness has to do is to make all of these confirmations, which make crystal clear what the purpose of the witness statement is and how they've done it. They have to confirm they understand the purpose of the witness statement is to set out matters of fact of which they have personal knowledge. They have to confirm they understand it's not their function to argue the case, generally or in particular, or take the court through documents. They have to confirm it sets out only their personal knowledge and recollection in their own words. On points they understand to be important, they've stated honestly how well they recall matters, whether their memory has been refreshed by considering documents, if so, how and when. They have not been asked or encouraged by anyone to include in the statement anything that is not of their own account. What this makes very clear is that there is no excuse for a defense of ignorance. One cannot simply say, well, I didn't know, or you must know, because you have to confirm that you understood all of these points.
And you can see the decent, honest witness who is trying to assist the court, who only wants to get it right, wanting time to absorb this, and time to think through the implications, and time to just consider. I think that the pressure deadlines impose on preparation with the need to sign this off will mean that you have to start planning the witness statement process from far earlier out. And I think when we look now at point 5 on the statement of best practice, this need to plan what you're going to do and to invest quite some time in doing that will sing out. Can you take us through the statement of best practice, Ruth?
Yes, Marion. So I think what's helpful to keep in mind when you think about the statement of best practice is the evidence that the working group had before it, because that has very much formed the recommendations or the ultimate changes that we see. The first is that they said that lawyers who draft this statement have very little guidance as to that process. And I think that's certainly correct. We don't have anything akin to this statement of best practice, hence why it is causing so many questions right now. The second point, of course, is that there's a vast disparity in terms of the seniority and experience of the people who draft these statements. So as you reflected earlier, oftentimes they can be junior solicitors, junior barristers. And I think this applies to everyone, not just the junior members of the professions, but very few have actually seen a witness being taken through evidence in chief. And we certainly see that reflected in many of the statements that we see. And so what all of that resulted in was universal agreement amongst the working group that an authoritative statement of best practice in relation to the preparation of witness statements would help practitioners in preparing these statements and would result in the production of more focused witness statements.
So Joe, can you fill us in on some of the rules?
Yes, so what this practice direction does in part, in fact, in large part, is to stress existing rules that witnesses should only give evidence to what they can speak to personally. It's not acceptable to provide lengthy commentary on disclosure documents, not to argue the case, not to use the statement for spin or comment, and it has to be as concise as possible without omitting anything of significance. But it does add additional requirements, as we've just seen in the confirmation they have to give, that for important disputed matters of fact, it should state in the witness's own words how well they recall the matters addressed, and also state whether, and if so, how and when, the recollection in relation to those matters was refreshed by reference to documents, and if so, identifying those documents.
And in fact, that picks up with one of the questions that has just come in, which says, what do you do where you have a witness who is, so to speak, the last man standing in an organisation? And we've all had that. The last person standing, I shall correct it, who doesn't have direct knowledge of events, the documents, but is the only person who could actually sign the statement. And as you just said, the best practice is you can only give evidence on matters to which you can speak personally. And if your knowledge is derived only from having been shown documents that you didn't see at the time, you weren't party to that transaction, it's going to be very difficult to be compliant with best practice. The next point I wanted to pick up was the preparation process, because it's quite prescriptive here as to how you actually go about taking the statement. Can you explain that, Philippe?
Of course, Marion. I mean, quite helpfully, actually, the prescriptive nature of this answers a lot of questions that you'd have. And the key paragraphs in the new PD on this are 3.8, 3.9, and 3.10. And 3.8 makes the perhaps obvious but important point that a witness statement should involve as few drafts as practicable. So that's meeting the criticism about iterations of a statement, changing one's recollection and version of events. Para 3.9 deals with the point about the legal representatives having to explain to the witness who's providing the statement the purpose and proper content of a statement and best practice. And also it says wherever practicable before any evidence is obtained from them. And so this sort of front loads the process so that there isn't a contamination in the evidence in ignorance of what the proper approach is. And then paragraph 3.10 goes more into the mechanics of this process of taking the statement. And it says, wherever practicable, it should be based upon a record or notes made by the relevant party's legal representatives of the evidence that they've obtained from the witness, rather than, presenting their own narrative to the witness for their agreement. And any such record or note should be made from, and if possible, during, i.e. contemporaneously, during an interview or interviews. And, it lists formats from face-to-face, video or telephone call, web chat or instant messaging. So it's recognizing the range of ways in which this evidence is often obtained, especially in cross-border disputes when you're dealing with logistical issues. And in any case, with the pandemic now, face-to-face interviews being less common. And it also, in para 11, gives us some more guidance on what the person who's leading a witness interview should be particularly mindful of. And I think these are reminders and would be familiar, but a key point is, avoiding leading questions, and on the flip side, using open questions as much as possible so that you're getting the witness's narrative rather than propositions that you're presenting to them, and to record as fully and accurately as possible what they have said. And in a sense, that's your proof, and that's what you're meant to work from.
Now, it stresses that it must go through a limited number of drafts. And we've been asked, okay, 1, 5, 10, how many? And I think, would it be fair to say we've come to the view, you cannot say how many drafts it can go through. But what I'm just going to share now is the case that I suggest. It's 20 years old. And I suggest if you've got a question about that, and if when you're establishing your procedures, have a look at that. It's available on Bailey. It will also answer the question, which has come up, how is anyone ever going to police the compliance certificate? How's anyone ever going to know that it shouldn't have been signed? This is the case which will demonstrate to you how it came out. And it involved, when it came to trial, the partner and the 2 associates who'd been involved in the taking of the impugned statement. Nobody suggested they'd got a thing, that they had deliberately got it wrong. But the witness was now facing an allegation of perjury. And that laid bare the entire witness taking process. And I think that's something that we could all usefully revisit and just put ourselves in the shoes of the lawyers involved and ask yourself, at which point now would you say we cannot go through another draft of this statement? So that's what we're going to say about that. Now let's move on, because I think we should now move on to the, unless anyone's got anything they want to add on that, we ought to look at this listing of documents, which is also generating a lot of concern.
Thanks, Marion. So I think this again might be one where it's worth showing the wording of what we're talking about here. The relevant section there you should have on your screen is paragraph 3.2. This refers to the listing of documents at the outset of a witness statement. It's worth noting that this is a point on which the working group itself was divided, but we do find itself in the final version of the practice direction. And what it says is that a trial witness statement must set out only matters of fact of which the witness has personal knowledge that are relevant to the case. And we've been through that and we can understand the difficulties that could cause in some cases. And then it goes on to outline the listing of documents. And what paragraph 3.2 says is, and the witness statement must identify by list what documents, if any, there may be cases where there are none, the witness has been referred to or has referred to or been referred to for the purpose of providing the evidence set out in their trial witness statement. So we can see 2 limbs of the requirement there, and it's important to emphasize them, that the witness has referred to or has been referred to. And it's important to note that wording because it relates to some of the questions that we've had in advance. Now, I think that it's also important to think about, when we're looking at that, the requirements for best practice and evidence in chief. And that's also a requirement which we see there. And it says in terms of the background to the requirements of oral evidence that it should keep in mind the documents that a witness might be shown if they were to give oral evidence. And that's also an important requirement that we see.
And you stressed that we'd had questions coming in that related to the documents that the witness has referred to or been referred to. Was that dealing with the situation of the witness who turns up having done their own prep?
Yes, exactly, Marion. So that's dealing with those kinds of circumstances where someone might have done their own homework before they come to the witness preparation. And it's essentially trying to put those 2 kinds of witnesses on an even keel, so to speak.
So you're going to have to manage that prep that's done. You're going to have to know and list the documents that the witness has referred to, even when you weren't there.
Yes, exactly, Marion.
And what do you do with the quite common practice where someone who is going to become a witness is actually involved in the evidence gathering process and the instruction gathering process at an earlier stage? So they've been involved in the preliminary preservation of documents orders, the preliminary search for relevant documents for the purposes of the pilot. what do you do then? Do you have to list those things that the witness had seen at that stage? What do we think about that?
I think this is quite a tricky area, but there is a bit of guidance in the PD, in para 3.2, which we've seen, and there seems to be the wording that we've looked at for the purpose of providing the evidence set out in their trial witness statement seems, on one reading at least, to allow for a distinction between the purpose for which a witness has been referred to or has themselves referred to certain documents, and that may allow you to not list, potentially hundreds of documents in that list, which also would defeat the purpose of the list, because it wouldn't really give you a good sense anymore of what has gone into that witness statement, because it'd be unlikely that all of those documents had relevance to that process. You could say, but this is again really a point for discussion, and new practices would develop, that there might be some benefit in thinking at an early stage about who's going to assume the document gathering or production function within an organization. And you might not want that, email inbox search and that kind of process to be done by your key witness. There may be very good costs reasons in any event for delegating that to a more junior member of the team. But I think that would also allow you to not fall afoul of this distinction. But in my view, it calls for a lot of judgment. And if you're unsure, I think you should put it in the list rather than the other way around.
I mean, how controversial was this list in the working group's conclusions? Do we have any feel for that?
It was discussed, and this was an area where I think the report says there wasn't complete consensus, and there was a real consideration of for and against arguments, and there was a bit of movement on the privilege exception, which we will come to later on. And this is definitely something where the group itself was, you could say, divided, but we do have the wording that we have, and I think the courts will probably work from that and not look too much beyond, we call it the travaux that led to the PD.
Yeah. One of the other questions that came up is, what do you do when it's gone wrong? And by gone wrong, and this is a very sensitive area, you've shown the witness a document and it would go in your list, and you don't like the answer. And we're going to assume perfectly properly you can satisfy yourself that the answer doesn't have to go into the witness statement. Okay. Now, I know that's tricky because the statement has got to be the truth and the whole truth. And personally, I think the statement which tells the true balanced story, the good and the bad, is inherently more plausible than the one that is just completely one-sided. It's like experts, it seems to me. But what do you do then? You've satisfied yourself that you can keep this answer out of the statement, but the document has been seen. Can you not list the document? What do we think, team? Who's got the short straw to answer this one?
Marion, sorry, can you clarify that again? So you've satisfied yourself that it doesn't have to be listed.
No, you've satisfied yourself the answer doesn't have to be in the statement.
Oh, I see. Yes, I think it's difficult, and I think there are 3 points that come up. The first point is that you have to ask yourself how it came to this, and one of the things the practice direction requires is a skill and a judgment call as to what to show the witness. So you have to think about what you want to show the witness and how that will develop. I think the second point then is whether you need to list it. And for that, we have to look very closely at the wording of paragraph 3.2 that Philippe and before we've looked at, and Ruth as well. So that the witness has referred to or been referred to for the purpose of providing the evidence. There is no guidance, given how new this is, as to the meaning of that. But the breadth of the words, in my view, would suggest that you have to list it. If you're preparing the witness statement, it's been referred to, then it seems to me it falls within the scope of those words. So you have to list it. The third point is that there may be complications if the document is privileged, and there is some guidance, but only very little, in the practice direction. And it says that, or rather in the appendix of the practice direction, and it says that privileged material may be identified by category or general description. But it seems to me that we may then be in a similar situation, like with disclosure lists, that for particularly sensitive privileged documents, there may be a challenge to whether privilege was properly asserted. And that would import a lot of the usual considerations for privileged documents and disclosure lists. You have to consider, while the practice direction says it can be identified by category or general description, in the particular case, may it be more appropriate to list and number every document that you assert privilege? And for the documents that you do list as a class of documents, how do you define that class or category? How do you describe it? It has to be sufficiently clear so you can identify documents that fall within that class or category.
I've been thinking, what am I going to, because one of the, it's coming up in the chat box, of course it is, what are people going to do with this list of documents? What are your opponents going to do with it? And I've been thinking, well, what will I do with it? I will obviously look to see, is this a witness who's been shown privileged material? Because that identifies where, can I call it, where on the food chain you are? There may be someone who is very, I thought, very low in the business, but seems surprisingly to be in that category of people with whom we will share privileged material. I will look to see what the witness has been shown, and I will compare with what the statement says. But what I'm really looking for is the gaps. So I'm looking for what they've not been shown, because that's where I'm going to cross-examine, or where I'm going to plan the cross-examination. What have they not seen? Does that make sense? Is there a glaring omission that I now ought to be exploiting? But beyond that, I haven't got any further as to what I'm going to do with it. Someone has said, well, what do you do if you've got the owner manager who always, the owner manager is your client and they always control the document collection process. It's just not realistic to stop them. And to which I think, correct me if I'm wrong, what you're all saying is be pragmatic. You can only charge what you can charge, and we still want access to justice, but just manage it. Know what they're doing. Be able to satisfy yourself that the list that gets signed off truly reflects what they have referred to or been referred to for the purposes of witness statement taking. And the record of when they collected the documents is going to matter, isn't it? Because you want a nice time gap between that process and witness statement collection. Anyone that want to jump in on any of the other questions that are coming up? I think there's a certain sort of pessimistic note coming into this. An air of fatalism is beginning to come out from all of this.
So Marion, we have had a question which I think is an interesting one on credibility, and it ties into your cross-examination question. I think sometimes, certainly when we're discussing these matters, we can very much get into the lawyer's mind and maybe forget or not think about as much what is the judge going to think, because of course the judge is going to look at this list as well. And that was certainly a concern amongst the working group that was raised, was the possibility of judges drawing adverse inferences from very long lists. And certainly I think we've all been in the territory of cross-examining someone and saying, you know, are you really sure that you remember that, hoping that the answer is going to be that they fall away and say they're not. But certainly if a witness has produced a very long list of documents, a judge might draw an adverse inference to that as well.
Yeah, and it's, I love the idea that a witness in their own words are going to explain the extent to which their memory has been refreshed. You know, I mean, I've tried that round the kitchen table in my house. What do I mean if I tell you my memory's been refreshed? The answers were unprintable, but revealed, you know, a complete lack of any insight into what that could possibly mean. And it's got to be in the witness's own words. It's going to be intriguing. Any other concerns about this? Do you think we've covered the bases?
I think one comment on that, Marion, I think while it says the witness has to form that view, I think the lawyers might actually be able to flag to the witness the fact that, you know, this was your proof or second proof. we showed you these documents and here's the change. And I think if you then read the statement and thought, okay, they haven't addressed that transition, I would almost think it's back to the lawyers to not kind of, you know, for every single document, but for key ones to just flag that and probably make sure that it's put in the witness statement, and then the witness can explain the change.
Be careful, but I like that as a practical tip, how you translate that. But I like that as a way of doing it. And there are all sorts of other reasons as well to keep these drafts, aren't there? Because you want to check that it's not going through too many drafts. So you do need to monitor how many times it's going out and coming back in redlining, if anyone uses redlining, and I hope you don't, because I've had too many nervous breakdowns over documents corrupted by redlining. Shall we, let's move on, unless anyone wants to chip in anything more on that. I think we're covering the questions as they're coming in. Please keep them flowing in. We've now got alternative ways, because they're closing the statements down for argument, submission, and commentary. Well, it's got to get out there somehow. So how are we going to do it? Any thoughts, Ruth?
Thanks, Marion. So maybe if I give the unsatisfactory lawyer's answer first, of saying where it's not going to go, and then we can think about how we can be creative. So on the first point of where it can't go, these are, of course, new reforms. They're going to change the way we all work, but they're coming into an established framework, and we need to keep those in mind. So for instance, we're not going to be able to put some of these pieces of information, which we'd like to shoehorn into a witness statement, into pleadings. Of course, pleadings are designed to be a concise statement of the primary facts relied upon. There's a raft of cases which demonstrate the importance of that, and there would be some difficulty shoehorning some of these pieces of information into those vehicles of pleadings. We also do need to think about in advance where we put this information, because we can't spring it at trial. I think it's said in the case somewhere that surprise is the enemy of justice. It certainly makes an enemy of your opponents in court. And there's a raft of authorities deprecating that kind of approach. And so you don't want to have any kind of ambush tactics as you try to deal with these changes as we approach trials, which are going to be listed after the 6th of April. But I think what is worth mentioning is something which has now fallen away from the current draft of the practice direction, but was included in some of the original thoughts of the working group. And that's this idea of a pre-trial statement of facts. And that would have set out the factual case for the parties. It's fallen away and it's not in the practice direction, no doubt, because the idea was that it was going to have to be agreed between the parties. And I think we can all imagine the amount of difficulty and time that might take depending on the nature of the case. But it was initially endorsed in principle. And so the importance of that, Marion, is that I wouldn't be surprised if we saw judges perhaps ordering something similar to that at something like a pre-trial review, or certainly if parties take that into account and think, how do we use things like chronologies? How do we think proactively and laterally in advance of a trial about the proper vehicle for this information to go in advance?
Yes, it's well, we'll come on to the cost implications of it all on point 9, because I think that it feeds into that. The naming and shaming, how clear are they that that's what they're going to do?
I think the answer is very clear, and Johan helpfully took us through the definition of relevant legal representative and the need for them to certify their personal belief in compliance. And the final report of the working group described this certificate of compliance in the following terms. They said, the named solicitor will be at risk of being identified if criticism is subsequently expressed. And in particularly serious cases, I think as a legal representative, you also need to be aware of the risk or prospect of wasted costs orders where that process has just not been followed properly at all. That's a serious sanction, and I don't see it happening as a matter of course, but I think you need to approach the task with that in mind. And as I think Johan will go through, there are several other sanctions for non-compliance that are more client side, you could say.
Yes, so what the practice direction does is to give the courts a raft of powers which it can apply in any combination. And what it can do on its own motion or on application, if best practice is not complied with, it can refuse to give or withdraw permission to rely on the trial witness statement. It can strike out part or all of the trial witness statement. It can say, go back and do your homework, and order that it be redrafted in accordance with the practice direction or as the court directs. It can make an adverse costs order. It can also order a witness to give some or all of the evidence in chief orally. And so to say, we'll turn the clock back 20 years and you go up there and you will explain in your own words exactly what happened.
So that's the raft, and it will remain to be seen when they implement those. If you asked me to speculate, I would expect an early naming and shaming on the right opportunity, because they'll want to send the message out to the profession that they meant it. And if you look at the pattern of all of these reforms, that has tended to be the practice. Of course, what they will also do is they'll take the first possible
Sorry, Marion, I think you might have just dropped out there slightly. Yeah. Well, I think one point that's interesting on this, Marion, if I can jump in on a point that we've got in terms of cost as well in advance of naming and shaming. I know it's something that others are concerned about. I can see it in the chat and the Q&A, no doubt producing some concern amongst those. Some are saying, will this be a concern in terms of, one example we've given, which I think is right, is convincing SME business owners to kind of front load these costs of the exercise. An additional question we've seen in the chat box, of course, is that being on the litigation side of things, sometimes it can be easy to forget that many of these cases don't go to trial and that essentially you're front loading that cost as well. And I think it is worth flagging that this is something that the working group did consider. When we look at the background report, they said that the time that might be diminished in terms of cross-examination may be taken up more in opening trials and closing arguments. But it's certainly interesting that we do have a test drive, albeit that it's a limited test drive, which does feed out some of these concerns that we've seen.
So am I back now online? Good. At least it wasn't a cat filter.
Exactly.
Yeah, and that's one of the, I've just been scrolling through the questions as well. That really is a concern. And I suppose from what I can see in the press is that it's a concern that they acknowledge, and they think it's a price worth paying. And I think that what we will have to think about is structuring alternative dispute resolution, because it's going to be all about that sweet spot when you know enough about the dispute to be able to give advice which will lead the parties to seek to find the resolution that works. And you're going to have that extra drive behind the costs that will come up with disclosure and with witness statements. And if you've got experts, as we know, they really do push the bill up. So it's going to be, I think, open day with the pre-action protocol process and some form of early mediation, or using one of the other techniques, early neutral evaluation, adjudication. And let's segue, I think, now into the point of, well, what are the implications of this? If I can leave you three to just check if there's another question that we ought to be picking up from the question box. Can I just share what I think you need to know? It doesn't apply in adjudication, and the whole nature of adjudication is such that it's going to be very difficult to fit it in. It's a 28-day process, it should be. I know it gets extended, but you're unlikely to have the big cross-examination. You're unlikely to have a meeting. It's going to be on the written material. But you will need, I think, to bear in mind that what we started with at the beginning is the toolkit and the mental mindset of someone who might be your adjudicator. They are going to be expecting the documents to be more reliable, and they will be irritated by the use of witness statements to convey matters of submission. So I think you need to bear that in mind. You're not caught by the rules at all, but that's, if you want to persuade someone, know that that's going to be increasingly their approach. And I think in international arbitration, the same applies. If you've got a tribunal, which are US trained, UK trained, they're going to look at witness evidence in a very particular way, being very comfortable with it, but they're going to be acutely aware of the limitations of memory. So is the ICC, one of the biggest institutions that there is. Where that starts, as we know, the other institutions will pick up. and they'll run with the ideas, they'll do the research. And if the data's right, memory is not reliable. And so the documents get the message across to the client. We've been saying it for every year I've been in practice. Keep the record, monitor the contract, read the contract, monitor it, apply it, keep the documentary record, keep the WhatsApp, keep the every single voice message, keep the emails, because that is where you're going to find the material to settle it. Anything else coming out of, yes, access to justice? Yeah, it is, but we can't sleepwalk into this. We can, if we prepare properly for this and manage this process, we can get our clients to the results they need earlier and in the economic free fall that we're looking at. That's what they're going to want. Don't push this into the file of something, it's too difficult. I've got a great big file marked too difficult. I'll look at it later. This mustn't go into it. This is too difficult. I need to look at it now, I think. But I'm sounding like Mary Poppins. I'm doing my Julie Andrews impersonation. I'll stop. Anything that you think we should pick up from the question, the Q&As?
There was another question about, how do you judge relevance of, say, key documents that a witness should deal with? And my own view is that the pleadings and list of issues, which you'll have at an early stage, probably should be your guide, and you wouldn't really be likely to be criticized for not appreciating the significance of a document that really maybe arises from a legal submission that's developed late in the day. Whereas if something is firmly an issue at that pleading stage and reflected in a list of issues, that really should be what you're looking at.
Do you think we'll see, because the TCC doesn't, correct me if I'm wrong, but it doesn't have the same commercial court practice with the common ground and the list of issues. And one can see the practice of requiring the parties in the commercial court to identify what's common ground could really be a useful tool now to identify matters that really let's not go there in the witness statements. It's agreed, and might perhaps see the TCC adopting that practice. That'd be interesting. Anything else you think from the questions that we ought to take?
The only point, Marion, that I'd pick up that it's a theme of some of the questions, and I wonder whether some of them are made by more junior lawyers like myself who might have to deal with the first drafts of some of these statements. Some people are asking questions like, do they have to exhibit their notes, all of that kind of thing. I think the main theme of these reforms is that you don't have to do that. But what we've been clarifying here is it's really important to keep an accurate record, both to protect yourself and, as Johan highlighted in terms of who signs the statement, to protect the process. And what these witness statements are always trying to achieve now is put those witnesses in their proper context so the court knows what information that witness can speak to and what they really can't speak to.
So in fact, we could end up with justice being done more often. Now there's a terrifying thought. I think I'm going to go back and look at my Zoom filters. We've come to the end. Thank you so much, everybody, for participating. We've had over 400 throughout this. We're very grateful. Thank you for the questions. They've been fantastic. Just to let you know, we are going to be monitoring this and the rollout of this in the coming months, and we'll be arranging some other events, and we will share with you as soon as we're doing that. And if you find that there are things happening that you're willing to share with us, please do, because this is a dialogue and it's a brave new world. Thank you very much.